Hello and welcome everyone. It's great to see all of you here. I see quite a few familiar names. I think we have a number of PHAP members in our global room today. So great to see you there, and also a lot of new faces, I believe, or names, I should say. For those of you who don't know me yet, my name is Anne Lang. I'm the Executive Director of PHAP, which is short for the International Association of Professionals in Humanitarian Assistance and Protection. And it's my great pleasure to be serving as your host for today's session. This is the 19th session in our series of online learning sessions on humanitarian law and policy. This is the first time that we're looking at the subject matter of refugee law. We're looking at the legal protection of refugees with guest and PHAP member Jean-François Derieux. So then, without further delay, we'll get into introducing today's session. As we said, the subject is the legal protection of refugees, and very pleased to have with us Jean-François Derieux. He'll be providing us with an introduction to the legal frameworks currently protecting refugees, with a focus on the purpose of the legal frameworks, the sources of law, and analyzing in particular four aspects: access to protection, qualification, asylum, and durable solutions. And I think it goes certainly without saying, this is a subject matter of particular relevance currently, given the protracted nature of the Syrian armed conflict, the broader situation in the Middle East, but also combined with other conflicts elsewhere in the world, which have contributed to what has been referred to as a, quote, global migration crisis or global refugee crisis, and there have been some major events and meetings recently in New York on the issue. And it's also been an issue where we've had a tremendous amount of interest from the PHAP membership in having some sessions to help them to understand some of the essential points related to legal protection for refugees. So it seemed like a good time to invite Jean-François to join us. I'll go through then the learning objectives for today. So specifically, we'll be aiming to help develop knowledge of key concepts in international refugee law specifically. Also raising awareness of other legal frameworks that also relate to protection of refugees. That would be including international human rights law as well as international humanitarian law. Also looking at states' legal obligations towards refugees, as well as the limitations of those obligations. The final learning objective is to look at the applicability of existing legal frameworks to the current migration or refugee crisis and challenges in applying the frameworks in practice. And then I was just saying a few words to introduce our speaker. Jean-François Derieux has had 3 decades-long career with UNHCR, during which time he served in Africa, in Asia, North America, and Latin America, and at headquarters. His last position in the UNHCR was that of Director in the Division of Program Support and Management. He's also taught international law at the Refugee Studies Center at Oxford, and for the last couple of years was the director of the International Refugee Law and Migration Law program at the International Institute of Humanitarian Law in San Remo in Italy, and is currently contributing both as a module convener and as a tutor to the distance-taught master's program in refugee protection and forced migration studies of the University of London. That's under the auspices of the Refugee Law Initiative. And his particular research interests over the years have focused on legal responses to mass influxes of refugees, in particular a comparison of African and European regimes, and a reflection on the legal implications of refugee emergencies and protracted refugee situations. He's also, as I did mention briefly in the beginning, a member of PHAP, like many of you, and we're very happy to have him here with us for this online session. So then I think I'll hand the floor over to you.
Thank you, Anne-Harriet. I hope everybody can hear me. Let me say first that I'm thrilled to be here in front of so many of you that I don't see. It's a great pleasure, frankly, to be speaking to you and also listening to your questions and comments about a topic which indeed is I suppose, as relevant today as it ever was, and probably that's an understatement. What I intend to give you in the minutes that follow is, as I put in the title, a quick introduction to international refugee law. It will be not only brief, but also quick. I'm afraid I'll have to take you through that jungle at a rather high pace. The devil is often in the details, as we know, so we may not see much of its ugly face today, but I hope that through your questions, we'll get into some of the more detailed aspects. I think it's important that we all get the basics first. And the first question that we must ask ourselves is why, first of all, do we have refugees in international law? And there are two main reasons for that. Clearly, refugees are a human rights issue, and in fact, most actually of my presentation today will focus on that dimension of international refugee law. It is a human rights issue. It is about the rights of people whom we call refugees. Therefore, there is a very strong vertical dimension in international refugee law, which is regulating the relation between one state and the refugees under the control of that state. But we should not forget that international law is also there, probably mainly there, to regulate the relations of states among each other, with each other, and refugees is also, of course, a very prominent issue there in the context of international security, international cooperation. So there are things that we're not going to discuss today, except perhaps through some of your questions that deal, for example, with the role of an international organization, such as UNHCR, which deals with the politics of refugee law, the relations, for example, between the country of origin of the refugee and the country that received the refugee. All that is, of course, part of the context, but we're not going to go much in detail into this. Generally, especially seen from a human rights angle, the purpose of international refugee law is to protect the rights of persons who cannot return to their countries without a serious risk to life or freedom. There are two implications to this fairly basic definition of purpose. One is that refugee, of course, is not a new phenomenon. However, the definition of refugees may change over time. Actually, it has changed, and it will continue to change, because at different times and in different cultures, you can actually have a different vision of what risks we want to protect people against, and therefore, who are these people that we call refugees. So that's never cast in stone. That's the first thing that we should bear in mind. The second thing is, of course, here we're talking about refugees, and refugees by definitions are outside their countries of origin. They're foreigners, if you wish. So internal displacement is out of scope of this presentation. It doesn't mean that there are no similarities. There are many similarities between what causes IDPs, what causes refugees, and the consequences, but that is out of scope of international refugee law. Sources. As a lawyer, I suppose I have to start with sources. In fact, international refugee law is a rather meager body of law. If we compare it with human rights law or even IHL, there are actually very few binding sources of refugee law. I have to start with a reference to Article 14 of the Universal Declaration of Human Rights, which I suppose could be said to have the status of customary law, that affirms a right to seek and enjoy asylum. As you can see just from that formulation, this is an incomplete right. People have the right to seek asylum, they have the right to enjoy it, they don't have the right to get it. And of course, that is where the rub is. Second, I suppose in terms of authority come a rule, sometimes referred to as a principle, but it's much more than a principle, which is called non-refoulement, which is my opportunity in an English presentation to say a word in my mother tongue. Non-refoulement, of course, means non-return. And the rule that you cannot return refugees to the place they have fled is indeed part of international refugee law as part of a treaty. We'll come to that in a few minutes. But it is also, according to many commentators, acquiring the status of customary law, which means that it is also binding on states that are not parties to the conventions that affirm it. I have to say here, non-refoulement is not unique to IRL, to international refugee law. There is a dimension of non-refoulement in IHL, and there is one also, a very strong one, in human rights law in general. But it is certainly one of the basic rules of international refugee law. Without that, the whole edifice will collapse. Then you have the two major instruments of universal vocation and application that relate to the status of refugees. That is the 1951 Convention and the 1967 Protocol, which actually are not bad in terms of membership, if you wish, since we have, as we speak, 148 states that are parties to one or both instruments. I cannot spend much time on the protocol. And in fact, I should not. It's not important. It was important at the time, but the only thing that the protocol did was to remove a time limitation that was imposed on the 51 Convention, which actually made the 51 Convention an instrument that can be used at any time, in any place. And I think that was, of course, a major achievement. If we continue with sources, in fact, what we've seen is what we have at, let's say, the truly international, universal level in terms of binding law. There's also, however, one piece of hard law, which is of major importance, and that is the African Union Convention of 1969. That is a supplement to the 1951 Convention. It's not a substitute for it. It's a regional treaty. Of course, it can only be ratified by states in Africa, and I think it has been ratified by all but 5 states in Africa. So an important piece supplementing the 1951 Convention. And then we have a fairly big body of soft law. I hope you're all familiar with the concept of soft law. So these are not binding obligations, but these are instruments that play a role in influencing the practice of state and also sometimes their own lawmaking at domestic level. So we have a flurry of UN General Assembly resolutions on refugees or on UNHCR. We have a flurry of documents called conclusions, which are sort of doctrinal pieces that are produced year after year by the Executive Committee, which is the governing body of UNHCR. UNHCR itself, as the agency responsible for refugees, also issues guidelines, some of which are fairly authoritative. So all that constitutes a rather impressive body of soft law, but for some reason that soft law has not solidified into much hard law since 1969. Finally, on sources, of course, it is important to bear in mind that refugee law does not apply in isolation. Human rights law is always applicable, and in armed conflict, IHL rules also come into play. Some of these rules, including in IHL, protect refugees very specifically. Others will protect refugees as civilians in the same way as in human rights law, refugees will be protected as human beings. Human rights law and IHL, in some circumstances, play an important role in the interpretation of international refugee law, but also in filling some of the gaps that are present in, for example, the 1951 Convention.
If you don't mind, we do have a follow-up question that I think would be well placed here as we're talking about the sources. The question is, in your view, is it important today to reaffirm the legal framework protecting refugees? And in particular, thinking about recent events, for instance, what has been reaffirmed at in the New York Declaration that was presented last month during the UN High-Level Plenary meeting on addressing large movements of refugees and migrants?
Thank you, Anne-Harriet. This is indeed a very good question. Am I still on? Yeah, okay, good. If I look at the New York Declaration, three paragraphs that start with reaffirm. And what is being reaffirmed there is basically what I've just presented. It refers to the institution of asylum. I think it's more than an institution. It refers to the principle of non-refoulement. I think it's more than a principle. And of course, it refers to the 51 Convention, the 67 Protocol. It mentions the OAU Convention. It also mentions the Cartagena Declaration on Refugees, which is a regional instrument in Latin America, which actually does not have the status of a convention, but also has been influential, as we will see in a minute. This is all very good. I think it is essential from time to time to reaffirm this. Why? Because this law is actually under attack. Many states that are tired with their commitments under international law are trying to write these commitments down. So it's very important from time to time to convene them, to convoke them, and to say, you know, can we clap our hands to show that we believe in international refugee law and what it represents. Having said that, that is clearly not sufficient. So in my view, it is necessary, but far from sufficient, because it is, after all, I would not say a weak body of law, but as I said, it is meager, and when it comes to implementation, a lot still needs to be done.
So thank you very much for that. It certainly helps with the clarification. Since we had paused, we have one more, I think, probably quick question for clarification, as we just mentioned IHL. So Elizabeth, wondering if you could expand a little bit on how or whether IHL actually addresses refugees other than simply as civilians.
Okay. I've just edited a full book on the question of the relation between IHL and refugee law, so I would definitely refer Elizabeth and others to that. But yeah, because even that short question is fairly complex. But is yes, there are in international humanitarian law specific references to refugees in the context of interstate armed conflict, because their refugees, and that is in the treaties, are to be treated as a protected category. And for example, the principle of non-refoulement is also applicable in IHL, because the occupying power has no right to remove the refugee population that was recognized prior to occupation back to its own country or to another state where those people would be in danger. So yes, those references do exist. Good. I'll move on. And here we have a wonderful animation, and I can never be thankful enough to my colleagues in PHAP. We'll have no time to look at every detail of this magnificent picture. What I would like to present, because that's the flow we're going to follow in the rest of the presentation, is this idea of refugee law being not necessarily an island, but this edifice. This thing, this mountain that people have to climb, and you do that by steps. And so in the following, we will take one step at a time. But it's also important to look at other aspects of this picture, including the condition of the boat, that I think is a reflection not only of boat people, but of generally the kind of conditions under which refugees do seek the protection of the legal edifice. There's also, as you may see, a back door there. The back door sometimes will be open, sometimes will be closed. It's a door through which some refugees manage to get in, but it's also a door that is used to expel refugees out of the protective regime. So this is what this landscape is meant to illustrate, and it does that, in my view, very well. I'm very proud of my colleagues, I have to say. Good. So we'll now try to take the first step. And of course, the first step is access. Access to a territory, of course, but more generally access to the legal protection system. What can we say about access and how it is regulated by law? The first thing is that the non-refoulement rule that I already referred to is supposed to secure admission. Right? Non-refoulement on its own means you cannot send people back. That assumes that the people are already in. But in fact, if you read Article 33 of the 1951 Convention, and of course you will and you have, it says that states cannot refoul or expel people in any manner whatsoever. And one manner that you can refoul is actually by refusing entry. Okay? So non-admission at the border is actually tantamount to refoulement if the place that people are in still is a place that is dangerous for them, right? So the non-refoulement rule is supposed to secure admission. That's a basic principle. The other basic rule contained also in the convention at Article 31 is that asylum seekers, that is people seeking asylum, should not be penalized for entering illegally. So law recognizes an important fact, that is that refugees most of the time don't have the luxury of collecting a passport, getting a visa issued, they just run. And as they run, they will probably reach a border and they will be treated as undocumented aliens, which indeed they are. But they are specially protected undocumented aliens. They should not be penalized for not having been able to secure all the documentation that is needed. These are extremely important. I would say they're really the foundations of refugee protection. They allow people, including undocumented people, to access the protective framework. However, the world is a bit complicated. First of all, there are obviously physical barriers to entry. These days, there's a lot of discussion about walls, about fences, and not just discussions. They are being built. They do exist. So these are, of course, very real obstacle. And of course, you also have the obstacle that the sea may represent for those that have no other option, if indeed the edifice we're talking about happens to be an island. So we see these barriers everywhere. That is, of course, a major constraint to access. Another one is more subtle because it is in the form of legal and procedural barriers. The fight against undocumented migration, which preoccupies states a lot, especially in those days where there is an amalgamation between terrorism and immigration, for example, and the rise of xenophobia and all that will affect refugees as well, because they need to access. And let's take just one example that does affect many refugees very concretely, the visa regime. The visa regime is not illegal. We know that we need visa to go to many places. However, for refugees, securing a visa and not being able to, maybe even if they're forgiven for not having a visa when they arrive, the problem is that the absence of a visa may stop them from leaving in the first place. This is especially true if, as is the case in many countries now, in Europe and far beyond, if the visa regime is enforced through sanctions that are applied to the transporters, to the carriers. So it means that you cannot board a plane if you do not have a visa, because the company would be fined very heavily and therefore will not take the risk of taking you, even if in the end you are forgiven and admitted into the territory. This applies not only to planes, but also to boats, for example. Why do so many people risk their lives crossing by in rickety boats or dinghies between Turkey and Greece, where the ferry, I think, costs €5? It's because they don't have access to the ferry for exactly the same reason. The ferry company doesn't want to risk the fines. So we also have these types of barriers. And then in addition to barriers, we have what I call loopholes. Is that refugees trying to access the protection which is provided by international law may actually be channeled out of the dedicated regime for refugees. This is the backdoor thing in part. And I'll refer here to three possible situations. They may be channeled out of the dedicated refugee regime for a good cause. This will be the case, for example, of unaccompanied children seeking asylum. Because in many states, the legal framework protecting children is more favorable than the framework protecting asylum seekers. Therefore, it will be advantageous for the kids to be treated as children and not as asylum seekers. However, that has the effect of siphoning them out of the dedicated regime, which for many kids has actually meant that when they reach 18 years of age and they're no longer children, they fall in a gap, because they were never recognized as refugees. So actually they may not be protected against refoulement at that time, even though for a number of years they were very adequately protected as children. Another form of loopholes would be that refugees are siphoned out of the regime for less noble reasons, not necessarily for a good cause. This is the whole debate about what is called in Europe subsidiary protection. Human rights actually protects people against other forms of refoulement, for example, to torture. There are many states who continue to claim that refugees fleeing from an armed conflict are not really refugees, which I contest, but that's an argument which is often heard. However, they need some form of protection. Whenever states say some form of protection, they mean some lesser form of protection. Unlike with children, they would not take those people to a higher form of protection. So they take them through a back door and they say, well, that's good enough because you are under some sort of protecting edifice. In the meantime, in fact, they've been taken out of the regime that was meant for them. And I think that in itself is dangerous. And then let's not forget this. I'm sure that many of you listeners here work in countries that are not parties to the 51 Convention and the 67 Protocol or the 69 African Convention. And of course there, all sorts of barriers, maybe all sorts of loopholes will exist because some states may not even have the refugee status on their books. In Thailand, I know for a fact, unless I'm contradicted by some of you, that it's almost impossible to even translate the concept in Thai language. It simply does not exist. You have to use a long metaphor. That says a lot about, the perception that people have. So indeed, many refugees, and I think that's the key message here, many refugees nowadays are actually not protected by refugee law. They're refugees nonetheless. Good. Now, you think that access is difficult, and indeed it is. Now, the second step is just as steep. I call it qualification, which is a word that I'm sure is familiar with all of you that have been trained by PHIP on IHL. But here it means something slightly different. In the law of war, what is to be qualified, first of all, is a situation. Are we in an international conflict or in non-international conflict? For refugees, it's not about a situation, it's about people. It's actually about the quality of people. For refugee law to apply, we need to define refugees and to find a consensus on a definition, and we also need a process through which refugees will be recognized. Okay, so this is what qualification is. Some of you would call it determination of refugee status. Recognition is the same thing. I have, I think, 3 or 4 questions under qualification. The first one is who decides? That is, which state will decide that a person is a refugee and therefore is protected by an international law regime? In principle, that responsibility falls on the first state in which an asylum claim is lodged. And again, in principle, that qualification must be respected and honored by all states in the regime. That's the principle. In practice, however, what we see happening in the regime is a lot of responsibility shifting. States are trying to evade their responsibilities not only to protect refugees, but even to determine who a refugee is. They can do that. They can do that and still be within some form of legality if they do it through agreement. If like-minded states or states that honor the same standards enter into an agreement as to who is going to decide who is a refugee, and then that determination will be honored by the other side. This is, of course, for those of you working in Europe. Oh. Hello? Yes? Yeah, okay, good. Sorry, guys. I think you lost me, I lost you. So I was saying that responsibility shifting can be done through agreement. Okay, and for those of you working in Europe, I'm told it's still good. Shout if it's not. That, of course, refers to the famous Dublin system, which, of course, would deserve an entire new whole seminar. But the Dublin system, which is now a regulation under EU law, is precisely about this, about determining which state is responsible to determine who is a refugee within the EU, so that you will not have multiple applications within the EU area. Agreements can also be handled bilaterally, for example, between Canada and the US. Now, responsibility shifting, unfortunately, also happens without agreement, that is unilaterally. And this is where a pretty bad practice that was introduced in Europe back in the 1990s is still alive and well, which is called the safe third country practice, because it's not a rule, but it's a practice through which some states will take it upon themselves to send asylum seekers back to what they call safe countries, without having determined whether they're refugees or not. So we're still at the phase of who decides. In practice too, and that speaks to the second part of the principle, that is, who must honor or respect a decision made by another state. In practice, refugee status is subject to reassessment by other states. That has something to do with what we'll see next, which is that there exists in the world more than one refugee definition. So states may say, yes, you are a refugee according to state X, but I don't apply the same definition, so please bear with me, I'm going to reassess your case. But unfortunately, this also happens a lot among states that are parties to the same instruments and should apply the same definition. This is just a symptom that there is a considerable lack of trust in the system. The next question is, once we know who decide, on what criteria, on the basis of what are you going to decide? And this is, of course, the whole issue of the refugee definition. Nowadays, the definition that is the most commonly applied and that has translated into EU law, for example, but also into the domestic law of most of states parties to the convention, is the definition in the 51 Convention. So you can say that that definition actually has a lot of resilience and it still has a validity that needs to be reaffirmed. However, as I said, it's not the only definition we have. We have regional supplements, and we'll look at that in a minute, in the EU Convention, in the Cartagena Declaration. What then again needs to be put here up front is that it's not enough to have a common definition to have consistent outcomes. If you look at the rate of recognition of, let's say, Afghan refugees in the world, you will see that in some countries the same people are recognized at 80%. And in other countries, sometimes in other parts of federal state, like in the US, you will have only 20%. So it's not because you have a definition that every refugee will be recognized consistently, and that is one of the reasons why refugees continue to move. Indeed, that's an important point. Let's look at these criteria. Okay, the basic criteria are in the Article 1 of the 1951 Convention, are well known to many of you. You have to be outside your country of nationality, with a well-founded fear of being persecuted. These are the key words. And persecuted not for any reason, but for one of 5 reasons that are listed exhaustively: race, religion, nationality, membership in a particular social group, or political opinion. So you will wonder, where is gender, where is age, where is disability, where is sex, where is sexual orientation, all these words that we find in human rights law prohibiting discrimination. It's a bizarre thing that discrimination is prohibited, but persecution does not lead to protection. Now, that has to do, of course, with the fact that the convention was drafted in 51, which means long before all the human rights instruments I've referred to implicitly. So what has happened is that it is mainly the membership in a particular social group ground that has been interpreted very creatively by courts in many parts of the world, and sometimes that has been reflected in legislation that allows, for example, gender-based persecution to be covered by the 51 Convention. However, if you ask me, I would rather have gender listed as a ground. Of course, you cannot do that without a new protocol. And then finally, you have to be unable or unwilling to avail yourself of the protection of your country, which may mean many things, but in simple language, it means you cannot return to your country without risk. Okay, so we are back to the basic definition. Let me just say that every of the words in that definition have been interpreted through zillions of court decisions. So here again, we could spend a day on this. And yet, that's not all we have, because we have two instruments. Again, one is a treaty, one is only a declaration. But what they've done is that looking at one particular region, Africa, and then later on Central and Latin America, they've said, well, the 51 criteria are fine, but maybe we need more. Okay, so again, this is not a substitute. Both instruments start by reaffirming the 51 definition, but then they add elements, and these elements are there. So people who are compelled to leave their country owing to external aggression, occupation, foreign domination, or even seriously disturbing public order are also refugees under African law. Those who have fled their country because their life, safety, or freedom was threatened by generalized violence, aggression, internal conflicts, massive violation of human rights, or other circumstances seriously disturbing public order are also refugees in those countries that have incorporated the Cartagena Declaration into their domestic legislation. Okay? This is important. At the same time, one question that needs to be asked before, and Harriet does, is how supplementary are these definitions, right? Do we really need that? Or can we, through a creative interpretation of the 51 criteria, cover the same people? And I would suggest that that applies, for example, to people fleeing war, who, in my view, most of them are covered by the 51 definition.
Thank you, and apologies for the interruption. We had a question from Francis. So going back actually to the first criteria that you mentioned, he's wondering, unable to leave their countries due to systemic injustices, be granted refugee status through UNHCR. Is it possible?
Okay, first of all, if the question is really about through UNHCR, I have to remind everybody that the responsibility to recognize refugee status is primarily the responsibility of states. I have no time to go into the mandate and the role of UNHCR, but you probably work in a place where UNHCR actually does determination of refugee status. UNHCR has to do that to know who their clients are. I appreciate that, but in some places UNHCR also does it as a substitute for states. Right? So, but these are different situations, and different rules would probably apply. So you're talking about somebody compelled to leave their country because of systemic injustice. I suppose under the Cartagena Declaration, you would clearly put that under massive violations of human rights, for example. Under the 1969 OEU Convention, the words are not there. Human rights is not even there. So again, there you have to resort to an event seriously disturbing public order, probably. However, in my view, you don't need that, because the 51 Convention definition would probably cover these situations, right? Under political opinion or under membership in a particular social group. Again, look at supplementary criteria only if the 51 Convention does not offer the protection that you're seeking. Thank you for the question. Okay, so now I cannot do a presentation on international refugee law without referring to exclusion. Sorry. So far what we've discussed are criteria that would allow people to be included in the protection edifice, right? Bizarrely, I have to say, the 51 Convention also has exclusion clauses. Exclusion clauses means there are some circumstances under which a person who is a refugee, according to the definition, still is not going to enjoy the protection of the legal edifice. And this is a rather unique device. And because it is rather unique, it's a bit, how to say that, counterintuitive to those of us who've been trained in human rights, I have to say, because it actually says some people can be sent back to persecution, tant pis. That's basically what it says. So it's obviously it's exceptional. It has to be used very cautiously. There are two justifications in the 51 Convention, notably under Article 1F of the Convention, two different justifications for exclusion. The first one is pretty straightforward. It says there are people there who are refugees. However, they don't need to be protected by the 51 Convention because they already fall under another regime. And what we have in mind there is actually the largest group of refugees in the world today who actually fall outside the scope of what we call international refugee law because they have a completely dedicated regime. These are Palestinian refugees. Palestinian refugees, as long as they are in the area of operation of UNRWA, which is the agency that, of course, is charged with their assistance, not necessarily with their protection, though, that may be a gap, they don't need to be covered by the 51 Convention. If they move out of the area of operation of UNRWA and have good reasons not to return there, then they fall ipso facto, automatically, under the protection of the 51 Convention. So it is an exclusion clause, which is also an implicit inclusion clause. That is actually one of the very good legal niceties of IRL for those of you who are lawyers. Then the other justification is much more controversial, I would say. It's about people who need protection, but they don't deserve it. And here you have basically two categories. You have people whom I call fugitive from justice. These are people who have committed a serious non-political crime before seeking asylum, so in another country. Of course, the regime does not want these people to be protected as refugees if it means impunity. So they can actually be excluded from refugee protection. And then there are people who have committed even more serious crimes, like war crimes, crimes against humanity, acts contrary to the purposes of the UN, of the African Union, in the case of the African Convention. And one thing that I didn't mention there, but I will mention it because it is in the Convention, and in one of your questions that I received before the session, it also talks about crimes against peace, which basically means a crime of aggression, right? Not everybody can commit a crime against peace. I tried, but no, I didn't try. But anyways, that is normally reserved for heads of state. Good. So the word that is important here is suspected. Okay, so the standard of proof in the exclusion clauses is actually not so protective as it is in normal criminal law. If there are good reasons to believe that a person has committed a war crime, that's enough to exclude a person. One example is for people who have been indicted before by the prosecutor for their case to be taken, maybe, okay, not yet, to the International Criminal Court. Indictment is usually considered as sufficient reason to exclude, even if guilt has not been proven. So a weird mechanism, but one that needs to be referred to.
So we have another few questions coming in, actually, that I think might go well here, specifically regarding people who are fleeing armed conflict. So Alexia and Mohammed's asking if you could perhaps explain a bit more why some states would say that people fleeing armed conflict are not refugees, and to what extent they can apply their own interpretations. And then there was a related question from Hannah, specifically about armed combatants fleeing a civil war across a border to another country. Are there special provisions for them to meet the criteria?
Good. Thank you. That's excellent. All right, I'll try to address these. I have to say this is one of my favorite topics, so thank you. Okay, first of all, why are states reluctant to? I think the reluctance of states to recognize refugees from conflict as refugees has little to do with their quality. It has a lot to do with their quantity. The fear is that conflict will generate huge numbers of refugees. Now, we have also seen situations where persecution produces masses of refugees. But there is this perception that if you have a conflict like we have in Syria now, then, as proven by the fact, 1/3 of the population will leave, and then we are overwhelmed by numbers. It is this fear that causes states to be very prudent about recognizing them as refugees, because they know if they recognize them as refugees, they have to give them a number of facilities, of rights, etc. Right? So that is the reason. However, if you look at the law, and I have to say that UNHCR guidelines, not least on refugees from Iraq and Syria, are very useful in that. Don't hesitate to look at UNHCR website for this, because UNHCR is arguing very well, in my view, that most people fleeing, for example, from the conflict in Syria, fall under the definition of the 1951 Convention. So you don't even need to have a supplementary definition like the OAU, etc. Why? Because if Aleppo is being bombed so systematically these days, it's not by chance. This is not indiscriminate. This is not random. It is because the people who live there are thought to have a political opinion that the regime doesn't like. That comes squarely under a fear of persecution, because loss of life has to be treated as persecution, as a risk, on political grounds. Even if these people have no political opinion, their political opinion is imputed upon them, and this is what causes them to flee. They are 1951 Convention refugees. I think that's clear. The second question.
Combatants.
Okay. Now, among the refugees, you might also have armed combatants or ex-combatants. This is a very difficult question of refugee law, because people working with refugees would prefer to believe that refugees are always civilians and that they cannot be combatants. However, if you look at the definition, it doesn't say that anywhere, right? So IHL applies. We've had in the history, and will continue to have, refugees who arm themselves, sometimes they are actually armed by their country of asylum, to continue the battle in their country of origin, right? Are these people refugees? Yes, they are refugees if they have a well-founded fear of persecution. Whether they wear arms or not is irrelevant. However, it's clear that if they take an active part in hostilities, they become legitimate targets. Right? The real problem that this poses for refugee law is not so much, in my view, about the status of the refugees, but about the status of the refugee settlement. Because what, of course, UNHCR and anybody that has a concern for the protection of refugees wants to avoid is that refugee camps become targets of military attacks, which has happened in the past and unfortunately will again happen on suspicion that these camps shelter combatants or former combatants, ammunition, what have you. So that is a very real risk for the refugees, and of course that should be our principal concern. But when it comes to the definition, let's just recognize that nothing in the definition says that by definition a refugee is a non-combatant. You can have combatant refugees, that is a fact. Okay, good. All right. Let's move ahead from criteria. So we know who decides, we know on which criteria. Now the question is, how do you decide? So this is whole question of process, procedures, and evidence. The rules governing that important area of law are simply not treaty rules. You will find nothing on that in the conventions that I mentioned so far. On the other end, you have a lot of case law, of court decisions in many jurisdictions about issues of procedures and issues of evidence. You also have a lot of UNHCR guidelines on the subject, because in states where you have these sophisticated procedures for determining refugee status, all these issues of procedure, of evidence, how do you prove that you're a refugee if you don't have an identity paper, for example, to take the most basic, all right? All these questions have been discussed and they've been decided upon. In EU law, I have to mention it here because there is actually there a very important piece of law which is indeed binding on 28 states, right? There is a directive, so that is a binding instrument of EU law, which actually talks not about the criteria but about the procedures. It's called the Asylum Procedure Directive. It was recast, that is corrected and amended in 2013, and it has actually a number of very good procedural rules. It's not perfect, but it's actually a fairly good instrument. And finally, on this point, I have to say, determination on a group basis is always possible, right? When you do that, and many states in the developing world, especially in Africa, have resorted to that, meaning they don't subject everybody to an individual procedure. They just say, if you have arrived after such a date and you are from such country, then you are a refugee because we know what's happening in your country. We don't need to ask you many questions about that. Okay? It's called prima facie. So at first sight, you are refugees and you apply that to a group. However, group determination is in part a misnomer because you apply it to every member of the group. It's not the group that is a refugee. If you do group determination, it means that every member of the group is a refugee. Okay? This actually is a very good formula where you have fairly obvious situations, and it doesn't have to be only in the neighboring country. Many states in Europe nowadays, they don't say so, but they're going to do group determination on Syrians. It means if you come from Syria, and unless there is suspicion of exclusion, that you may be a bad person and not just an innocent refugee, I think that most states will probably have to resort to some form of group determination. They will not say that publicly because they like to show that they're in control and that individual procedure is what they do. But in practice, when you have 1 million asylum seekers in your country, if you don't resort to group determination, you lost. Okay. Hey, so ready to move to the third block. I'll go actually very fast on the last two, and that's not to diminish their importance, right? In fact, this block here is where we want to get, okay? If refugees want to access a protection system and they want to overcome the obstacle to prove that they are indeed refugees according to a recognized definition, is in order to enjoy something. And that something is called asylum, okay? Asylum here means the set of rights and obligations that refugees have once they have been recognized as refugees, okay? They get asylum. I know that in different languages it may mean different things. So I'm giving this color to it here. So asylum is composed of what? In fact, the 1951 Convention is largely an instrument about asylum. It refers to the status of refugees, and the status is precisely that. This is, what do you get once you are recognized as a refugee? However, the first question to be asked is not what do I get, but where. Now, this sounds, I know, a bit illogical, because logically, that island should really be one place. I've managed to access the system through one state, in one state. That state has qualified me as a refugee. Logically, this is the place where I will enjoy asylum. In practice, this is the reality. I suppose that over 90% of the refugees in the world actually get some form of asylum in the country that has recognized them as refugees. However, I want to insist that this is not a rule of law. It's a question of chance rather than a question of law. If you read the convention or any other piece of international refugee law, you will see that the state that has determined you to be a refugee actually has no obligation to keep you forever. Not even for the time that you are a refugee. That responsibility may still be shifted to another state. Back in the 1970s, there was a major attempt to draft another convention on territorial asylum. And the purpose of that was indeed to make sure that it was clear which state was responsible to give asylum post-recognition. That convention was never adopted. It aborted. States were not willing to commit to anything. So it remains largely ad hoc. In practice, it is chance. And sometimes the choice of the refugees, sometimes, in most cases, just geographic proximity. The vast majority of Syrian refugees are in the countries neighboring Syria. The vast majority of refugees from Burundi are in Tanzania because that is the country that is the closest, right? So it happens. It's not necessarily legal, okay? There's only one instrument in which physical burden sharing, that is, how do you share the refugees once they are recognized by one state as refugees, which of course is the big issue today, in Europe and anywhere else, but it's an issue that plagues every refugee crisis. There's one instrument in which there is an attempt at regulating it. That is Article 2 of the AU Convention. The AU Convention, the African Convention, I mean, does not have a formula. It doesn't say, you know, if you get more than so many refugees compared to your GNP, then, you know, another state has to take over. No, it just said that all states in the African Union, in a spirit of solidarity, have to come to the rescue of states that are overburdened with the presence of refugees. It's not really practiced. There's actually very little sharing of the burden. I mean, the sharing is again ad hoc, okay, because people move on. But there's no formalized sharing, even in Africa. However, the rule exists, and it's a rule that the rest of the world would be well inspired to look at, because I think that's the beginning of a system of responsibility sharing. Okay, quality of asylum. So what is in that legal edifice? What do I get as a refugee? Here, this is where, of course, the inspiration comes from the 51 Convention. The 51 Convention is a boring instrument to read, I have to warn you. No, it is. It's very convoluted because it doesn't say all refugees have the right to work. No, it says that refugees with lawful residence in the country, okay, have the same rights as foreigners in the same circumstances, or with the nationals of that country, or with aliens in general. So it's very complicated, frankly, to try to reconcile that. It's possible, but it's a bit painstaking. The logic, though, because there is a logic in all that, is that over time, refugees will get more and more rights and more facilities. Okay, that is the compelling logic, that time itself will actually mean an accrual of rights. So as you get in and get recognized, maybe you get very little. You have the right to your family, you have the right to go to court, but you don't have the right to work at the same level as nationals. You don't have the right to send your kids to university free, etc. Okay, but gradually you will be assimilated more and more to nationals. And in the end, you can be, if the 51 Convention is applied fully, almost like nationals, except of course for political rights, for example, because that there is a more general rule that applies. For example, that foreigners, and of course refugees are foreigners, for example, cannot be elected to parliament. Fair enough. But however, they do acquire political rights too, but not all of them. So that is the logic of the convention. So the quality of asylum is going to increase over time. In what I call the global north, which has no definition, I know, and actually it extends also beyond that, but in many, let's say, countries with well-developed welfare system, for example, you will find that refugees benefit from integration standards that are much higher than the convention. The convention, that is important to bear in mind, that is the minimum, right? These are minimum standards. And of course, you are welcome to do more. I put there well-behaving refugees because that is, of course, a major obstacle to integration, not just of refugees, but of foreigners in general. If you commit a crime or an infraction in your country of asylum, you probably go a few steps back on the road to integration and assimilation. That's a fact. Now, the real issue about the quality of asylum is frankly not when we have small groups of refugees arriving in rich countries. The big problem is when we have large groups arriving in less wealthy countries. And as we sit in Europe today, large groups may actually even affect the quality of asylum in rich countries. I think it's shameful, but it's a fact. Large-scale influxes result in substandard conditions. And when I say substandard, I take it in the legal sense, okay? That is below what the convention commands, okay? This is against the letter and the spirit of the convention. Against the letter because the convention says these are the standards, and the spirit because indeed what happens in large-scale influxes, we can all imagine refugees who languish in camps for 10 years or more. the logic of the convention there is beaten because they're frozen. They're frozen. In year number 10, they have the same rights as day 1. This is wrong. This is against the spirit of the convention. In the EU, there's a mechanism that has been invented to deal with mass influxes. If you ask me why it has not been used in the crisis that we face today, I have no good answer for that. I think it should have been. It's called temporary protection. If there are questions on that, I'll be willing to answer, but it's a very complex issue. In short, it's the same thing. It is a regime which is actually there to protect people arriving in large numbers from the same place at the same time, but it will give you less rights than full refugee status. So it may actually contravene your obligations under the 51 Convention. It's one of these very ambiguous areas, even in the EU.
So a quick follow-up question, since you were speaking about the unfortunate possibility of substandard conditions in developed countries. We had a question from Celine regarding what legal mechanisms could potentially currently be used to enforce EU member states to respect the legal frameworks protecting refugees, given that they're not being fully implemented now.
Thank you, Celine. This is an issue that goes far beyond the EU. All right. We have a general problem with international law, right? Which is the question of implementation, supervision, enforcement. How do you enforce international law? Like many other pieces of human rights law, for example, international refugee law is actually enforced at the domestic level. It is through its incorporation into domestic law, which, by the way, in the EU is now mandatory because the directives have very largely represented everything that the 1951 Convention says. They have not filled the gaps of the Convention, but I think they've represented the Convention fairly well. So there you have a binding framework. What do you do if a state violates the convention? Not much. UNHCR is there and will receive complaints, but not in a formal way. Okay, not in a formal way. There's no tribunal before which the state will appear to respond. Under EU law, though, the directives, of course, are to be applied, and therefore, if there's a violation of the directives, that can be taken to court. In fact, the Commission or another EU member state could actually take a violating state to court, that is, to the Court of Justice of the European Union. That is not happening much. Why? Because of fear of reciprocity, right? So it's the big issue of international law, again, which you see reflected in this small club of 28 states. So there we don't have extremely effective mechanisms, but I think the most effective mechanisms are at the domestic level. If the practice of the state in question carries a risk of refouling refugees to a place of danger, well, then that will probably be, that will certainly be criticized by the European Court of Human Rights, for example, and possibly by domestic jurisdiction that apply their own human rights framework and the EU directives. Good, thank you. And so that is about quality of solution, and there's an immediate link with solutions, because asylum should lead to something. And the word solutions is actually not in the 51 Convention, but it is, and those of you working in or with UNHCR will know that well, it is actually in the statute of UNHCR. UNHCR was created to provide international protection to refugees and to seek permanent solutions to their plight. Okay? Now, the statute says permanent solutions, and so I would like to spend a minute on permanent before I tone it down to durable, which is what the doctrine does. The basic rule is the following. Refugee status cannot be forever. It cannot be forever for the sake of the people concerned, but also for the sake of states. Refugee status is something very exceptional. It actually confiscates the protection of the state of nationality and gives it to another state. It's something that should not happen in the normal way that states relate to each other. So for all these reasons, it has to come to an end, right? It's good for states, it's good for refugees, that it comes to an end. So refugee status must cease. And the 51 Convention provides for that. Actually, in the same Article 1 that has the definition and the exclusion, it also deals with cessation. Even though cessation is not something that will be determined at the level of entry, but many years sometimes after the arrival of the refugees. And basically the convention says that there are two sets of circumstances under which refugee status will come to an end. One will be the refugee's choice. So we can think of voluntary return. The refugee one day says, now it's time for me to go home, it's safe. I decide, I reestablish myself. Of course, he's no longer a refugee. Okay? Or because conditions have changed durably in the country of origin. Now, this is something different because here it's no longer the refugee that makes the assessment, but the country of asylum that says, you know what, guy, the situation that forced you to come here is no longer there, so maybe I don't need to renew your refugee status. Maybe it's time to go home. Or maybe to change status, because the important thing about cessation is that it does not necessarily mean expulsion. Okay? There are many refugees in the world today that, no, many ex-refugees who once were refugees. Let me give you an example. There was a time, most of you were not born, where in fact the typical refugee in Europe was fleeing from Eastern Europe. Right? These days are gone. Okay, and hopefully they will not come back again. So you had Polish refugees, you had Czech refugees, you had Hungarian refugees, right? At some point, after the changes that we saw since 1989, the states had to say, well, these people are no longer refugees. All these people still live in the countries where they were refugees. All what that happened is a change of status. And many of them, of course, got the nationality of the country of asylum, which is my next point. So, why are we talking about durable solutions? Because, in fact, we should be talking about refugee status coming to an end forever. And indeed, there are only two permanent solutions if you look at it. Okay? Either you go back to your country and you are able to reacquire all the rights that are linked to effective nationality. When refugees leave their country, they don't lose their nationality, right? They're not stateless, right? Syrian refugees are Syrian nationals still, but they don't have effective nationality. One day, hopefully, they'll be able to go back to Syria and to be again enjoying effective nationality. Then, of course, they're no longer refugees. If that doesn't happen, then in order not to be refugee, you have to acquire another nationality, which means that then again, you are under a fully effective national protection status. You don't need international protection. It's very simple, okay? Which nationality will you acquire? As part of asylum, if you wish, as part of this gradual acquisition of rights, the 1951 Convention, really close to the end, at Article 34, I think, says, well, states should facilitate the naturalization of refugees. So it's not mandatory, okay? It's not mandatory. And refugees who want to apply for naturalization have to follow the same procedure as others, probably meet the same criteria. The only thing that the convention requires is that they be given some facilities. For example, if they cannot produce a birth certificate because of the fact that they are refugees, that should be forgiven. Maybe they should be exempted from fines, etc., from fees, etc. So it's an obligation to facilitate, not an obligation to naturalize. Naturalization of refugees does happen a lot after many years and never en masse, right? There have been very few examples of naturalization en masse. There was one that was highly publicized in Tanzania, but it was after more than 30 years in exile. Okay, I've been witness to one in Mexico, which was a group of some 30,000 people who acquired Mexican citizenship as a group. That was after 20 years of exile. These things do happen, but mostly it is on a case-by-case basis if you meet the criteria. Naturalization also happens through what we call third country resettlement. That means that naturalization will not be granted in the country where you first arrive, but in another country that will take you as an immigrant. Okay, that process is known in refugee parlance as resettlement. It's not resettlement within one country, it is third country resettlement. The US, Canada, Australia, other immigration countries do resettle refugees by the hundreds of thousands every year. Never enough, but it's something, because most of these people will have a very quick channel to naturalization once they arrive. I think in Canada or in the US now it takes less than 3 years or 5 years to become a citizen, and there you are no longer a refugee. But if people tell you resettlement is a permanent solution, they're wrong. Because the people who are resettled as refugees. They will cease to be refugees only when they acquire the citizenship of their country of resettlement. What we have in law is actually very weak on solutions, I have to say. I already mentioned this naturalization thing. It's only a recommendation. There is no right to a solution. There is a right to protection. There's no right to a solution. So the final question is, and I already alluded to that, is where will durable, if not permanent, solutions happen? Of course, the preference would normally go to the country of origin, the country of nationality, because basically you can solve the problem. Okay? So that happens through voluntary repatriation. Voluntary repatriation in itself would deserve a full seminar, because when is it safe for people to return? If people volunteer to return to a place that I consider as dangerous, should I let him go? These are all very valid questions. There is a bit of law on this though, and the bit of law is in form of bilateral or trilateral agreements that are coined between the country of asylum, okay, the country of origin, and UNHCR. They come together and they say these are the conditions for return. Okay, even for voluntary return, we need these conditions before return and after return. And then these are firm commitments. In fact, these agreements are treaties, right? If that cannot happen, and unfortunately for most refugees that is not at least an immediate option to return safely to their country, then durable solutions can be offered in the country of first asylum through what we call local integration. You have to know that this very concept is actually highly contested in the major host countries, especially but not only in the developing world, because of the objections we've seen about mass influxes. How can I integrate 1 million refugees? It's actually a very big question. How can the Lebanon integrate refugees that represent 50% of the population of the country? I have to say that in Europe, integration rights, if you wish, are increasingly recognized by the jurisprudence of the European Court of Human Rights. This is not at all a principle of refugee law, but it's one which is very helpful to refugees too after a while. It says that with time and ties, you actually acquire rights to remain. So the more time you spend and the more ties you create with your country through residence, through work, through marriage, etc., then the more difficult it will be for the state to expel you, which means basically that they will have to integrate you. Okay, but again, this is not a refugee law rule. It's a rule that is derived from human rights law. And then, as I said, sometimes durable solutions are offered in another country of asylum through resettlement. In most cases, it will lead to naturalization, but it could also not lead to naturalization. Then it would just be a transfer of responsibility from the first country of asylum to a second country of asylum. And let me finish by saying that in Europe, we actually have a very old convention on transfer of responsibility between states, which is never looked at. And it's a real pity, because I think that in part it could actually solve some of the problems that we see in the management of the current crisis. Good, I'll leave it at that, and I'll be impatiently awaiting your question. As far as I'm concerned, that's all false, and I don't have the music that goes with it.
Excellent. Thank you so much. Really terrific presentation. I know that I learned a lot, and I can see from the questions that came in and the comments also very much appreciated by all of our participants. We do have a lot of questions. I'll say up front, I'm glad that we managed to squeeze some in during the presentation. There are many more still remaining that we won't be able to address today live. However, we will, as we do with our other learning sessions, try to ensure that those questions are answered in writing, and those then can be available to you as a resource after today's presentation. But moving to a couple of questions that we do have time for. We have a number of people concerned about the concepts of irregular migrant or forced migrant, and also the concept of environmental refugees, and wondering, do these have actually any legal meaning? How is international law dealing with new forms of, quote, refugees, so displaced by natural disaster? Is international law ready to accommodate the new so-called environmental refugees? That's questions from Denise and Zafiro in particular.
Good, 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 excellent. I'm not really surprised by that question. It goes to one thing that I think is important to bear in mind, is that here we've been talking about refugees as a term of art in international law. But in common parlance, we use refugee to describe all sorts of other people. So I think it's a good question to know, what exactly are the limitations, what is the actual scope of the refugee concept in international law. But I'll start with irregular and forced migrant, because indeed, forced migrant has no definition in law. It is just a convenient way of expressing, for example, the similarities between people who are displaced within their own countries, they're forced to migrate internally, and those who are forced to migrate externally, who then would be refugees. But you don't have, and I don't think you will ever have, a convention on forced migrants. Irregular migrant, on the other hand, is indeed a technical term of art. Because an irregular migrant, and here I'm supposed that we're talking about an international migrant, that is somebody migrating from one country to the other. Each country, of course, has the right to impose rules regulating the entry and stay of foreigners. That is not at all against human rights law. So some people are regular and other people are irregular. And interestingly, some refugees are regular and some refugees are irregular. We come to consider that all refugees enter irregularly. This is not the case. I was in Morocco last week training judges on refugee law there, and I met a person who came to Morocco as a student. He's from Central Africa. When he left his country, he was okay. He had a visa and everything else. Then war started in Central Africa. He cannot go back. He is what we call a refugee sur place, right? So he's fully regular in the country. So again, there's refugees fall into all these categories. They're all forced migrants, but that has no legal definition. Some of them are irregular, and others are actually regularly in the country in which they seek asylum. They're still refugees. Now, refugees, does that cover environmental refugees, climate refugees, etc.? Well, no, it doesn't. I mean, the definitions I gave you very quickly, I admit, is what we have in hard international law. It may be terribly unfair. There are people who claim that hunger pushes people away from home under as dire conditions as war does. Fair enough. What I'm describing is law, which means a consensus of states. Currently, there is no consensus of states that people who flee from hunger to another country are refugees. There's no consensus that people who flee from a natural disaster or from climate change are refugees. However, it doesn't mean that these people are without protection. I think this is really the point. And I think that the Nansen initiative, that was this initiative to look at the protection and the rights of people who find themselves outside their country, and their country is hit by a natural disaster, and therefore they cannot return, they need some form of protection. And in fact, they do get it. I would suggest that, I mean, I'm not going to generalize here, but I think that victims of natural disasters are generally received with compassion and empathy. which is not always the case of people who flee from political disasters, because then, you know, it depends who you are and who they are. It depends on your vision of the world, it depends on geopolitics and all that stuff. So I don't think that we need to call the people who flee natural disaster refugees for them to be protected. They're protected by human rights. There may be some procedure that must be put in place, but I don't see the need to put them under the 1951 Convention as such.
Okay, thank you. We also had a couple of questions regarding the EU-Turkey agreement and whether or not it's in accordance with the 1951 Convention.
This is the $1 million question, or I should say maybe the €3 billion question, since apparently that is the price of the agreement. On its face, it's legal. It can be contested and attacked from many angles. And one angle that I would just like to allude to is, what is the point of a treaty? Here we're talking about the 51 Convention, and you may or may not know, but actually Turkey does not apply the 51 Convention to refugees from outside Europe. This is another oddity of the system that allowed back in the 1950s some states to make that sort of rather silly reservation. And Turkey has maintained this reservation to this date. Yes, they do have a temporary protected status for Syrian refugees, which gives them a number of rights. However, they do not recognize them under the 51 Convention. So a question of international law may be raised here, because in effect, Syrian refugees transiting through Turkey and then arriving, let's say, in Greece, get access to the famous island that we've seen, the one with the 4 blocks, only in Greece. All the time they're in the Lebanon, in Jordan, in Turkey, they may have access to some protection, but that's not the 51 Convention protection because it does not apply to them. So I think that point needs to be raised, but it has to be raised in court. I'm sorry, that's the only way that it will be proven, right? Whether actually the treaty obliges you, if you are the first state party to which a person can apply, does it oblige you to make that determination? I call this the Australian job, because Australia has tried very hard to do what the EU is trying to do with Turkey, as some of you probably know. And at some point, Australia had a deal with Indonesia, so that Indonesia would actually take people back and determine their refugee status under the auspices of UNHCR and all that. And thank goodness the Supreme Court of Australia ruled that it is illegal for Australia to send people back to Indonesia because Indonesia is not a state party to the 51 Convention. I think that was a very powerful argument, and one that I haven't heard expressed much in Europe. Now, beyond that, if you want to contest the legality of the agreement, unfortunately, you need a violation. Okay? All it takes is a violation, and by violation, I mean a case of refoulement from Turkey, right? And of course, I would prefer that there be no case of refoulement from Turkey to Syria. However, it is only on the basis of that you can take a case to court, either to the European Court of Human Rights or under the domestic legislation of the refouling country by application of EU standards or 51 Convention standards. Because the deal is illegal if there is a risk of refoulement. That's clear. That's your bottom line. But the risk of refoulement, you cannot, in my view, you cannot establish it in the abstract. You need a case. I'm sure that some lawyers are already working on this.
Excellent. Thanks so much. We are unfortunately coming to the end of our time here. So as I mentioned, we will do our best to ensure that all of your questions are followed up after the session so that those will be a resource for you and you'll receive an email about that. But now before we close, and I will mention a number of other upcoming events that may be of interest to you, I would just like to very warmly thank Jean-Francois. It's been fantastic to have you here with us. Thank you so much for the session. If you'd like to have the floor once more for very brief concluding thoughts, it's all yours.
Yes, thank you. Yeah, you know me by now. It's hard to stop me, but you just did. So congratulations. Now, of course, I want to thank you all, PHAP, for organizing this. It's fantastic, and for all of you, I'll look forward to receiving your questions, and I'll do my best to answer in writing. I'm mostly retired these days, so I will have time to look at your questions. I'm sure they're challenging, and I hope that this session will be followed by others. Really, that is my wish, and if you support that, say so. Because, as I said when we started, the devil is in the details, and there are so many details that we could usefully look at. Thank you, in any case, for your interest in this matter. That's very much appreciated.
Excellent. Thanks so much. And yes, that's a perfect link, I think, to looking at some other sessions that are coming up, but also to say that, yes, this is overall an area where there's clearly quite a lot of interest, some ongoing questions, and we'll be looking forward to work with Jean-Francois and others in the PHAP network to make sure that we do continue to have sessions in this area. There were also several people asking actually in the chat and in the Q&A about whether we would also have separately an online learning session on the protection of internally displaced persons. In fact, yes, we are looking to have one, if not by the end of this year, then early in the coming year. So we'll certainly be notifying you about that as soon as it's on the schedule. But yes, we will be also having a similar learning session on IDPs. And then following up with related issues. So then I'll just go on to my kind of concluding remarks here regarding the recording of today's session. That will be available quite soon. It will be accessible on the event webpage. You have the link there in front of you. Also, the resources that were mentioned during the session, and Liz, thank you so much for posting a number of them in the chat. That was very helpful. Those will also be compiled and everything will be sent to you together in a follow-up email. Then looking ahead in our calendar, so we have several other sessions coming up in our Law and Policy series. On the 15th of November, we'll be looking at the legal dilemma of detention in non-international armed conflicts with Gabor Rona from Cardozo Law School. Then we will be looking on the 1st of November at a very particular issue of concern. It's presented as an advanced session, so we can say it's particularly targeted to those of you who are legal experts, really digging into some of these challenging issues related to developments in technology, accountability, and international law, looking at the concepts of autonomy that affect conduct of hostilities and other elements. That will be with Naz Modirzadeh and Dustin Lewis from the Harvard Program on International Law and Armed Conflict. Then on the 8th of November, we have a session with Bonnie Doherty, who's also with Harvard Law School, on the issue of hostile intent and civilian protection, looking at some specific examples from recent conflicts, for example, in Iraq and Afghanistan. And that's it for now in this series. So you can already register for those sessions if you are interested in joining us. And otherwise, we will keep you informed of other events in this series as they come onto the calendar. Thank you so much for being with us. It's really been a pleasure, and we look forward to being in touch with all of you again soon. This is Gerard Lang and the whole team from PHAP here, signing off for now from Geneva.